Recording in progress. Interpretación español para probar.
Vamos a probar interpretación. Probamos español. Siguiente que
¿Cuál es acá?
consola, español. Uno. Ya un minuto que estamos probando con la comisionada. Ya voy para allá. Pasamos a la cabina de inglés. Perfecto, pasamos a la siguiente. Ok. Perfecto, gracias Rosy.
Muy buenos días a todos y todas. Expreso un cordial saludo a la distinguida representación de las presuntas víctimas, a la delegación del ilustre Estado de los Estados Unidos. Voy a dar por abierta la audiencia en este caso, el caso 14.543. Mostafa, Seyed, Mirmehdi y otros respecto de Estados Unidos. Voy a cederle la palabra al secretario ejecutivo adjunto, Jorge Mesa, para que haga la referencia particular sobre este caso.
Muchas gracias, vicepresidenta. Muy buenos días. El presente caso se relaciona con la alegada responsabilidad de los Estados Unidos por la presunta detención arbitraria de los hermanos Mohammad Reza Mirmehdi y Mostafa Mohsen Moitaba, todos Seyed Mirmehdi, en el marco de su presunta participación en una manifestación, lo que a su vez habría derivado en las alegadas violaciones al debido proceso, la igualdad ante la ley, la libertad de expresión, el reconocimiento de la personalidad jurídica y a sus derechos de reunión y asociación establecidos en la Declaración Americana. La Comisión Interamericana notificó su informe de admisibilidad el 21 de abril de 2021. La parte peticionaria, por su parte, presentó sus alegatos respecto del fondo el 20 de octubre de 2021 y el Estado ha presentado sus observaciones adicionales el 29 de julio de 2022. Esta audiencia tiene por objeto recibir las declaraciones de dos presuntas víctimas y profundizar los... Okay, we can go. Okay. Decía por último que la presente audiencia tiene por objeto recibir las declaraciones de dos presuntas víctimas y profundizar los alegatos de fondo de ambas partes. Gracias, vicepresidenta.
Gracias. En primer lugar, la comisión escuchará el testimonio de la presunta víctima Mostafa Seyed Mirmehdi, perdonen la pronunciación, que ha ofrecido la parte peticionaria. El testigo declarará sobre su experiencia en detención, las presuntas violaciones a la libertad de expresión y el debido proceso, el impacto en su vida como consecuencia de las presuntas violaciones a los derechos humanos y las reparaciones que considera necesarias. La parte peticionaria tendrá 10 minutos para realizar el interrogatorio. Posteriormente, el Estado, si así lo estima pertinente, tendrá 10 minutos para el interrogatorio a la presunta víctima. Y finalmente, la comisión realizará las preguntas al declarante. Señor declarante, sírvase indicar su nombre completo, su lugar de nacimiento y lugar de residencia.
Sorry. Thank you. Good morning. My name is Mohsen Seyed Mirmehdi. I was born in Iran and I live in the United States, California.
Vamos a dar entonces inicio al interrogatorio por la parte peticionaria y las respuestas del señor declarante. Por 10 minutos.
Thank you very much, President. Good morning to the commissioners. Good morning to the Executive Secretary of the Inter-American Commission of Human Rights, the USA government delegation, and those present in this hearing. I'm Paula Angarita, and I'm going to do the questions. Mohsen, what were the reasons that you decided to move to the United States?
I believe in freedom and democracy, and the reason I came here is that we had a lot of problems in my country. My parents were against the government. We we were subjected to persecution over there. One of my brothers, Mostafa, he was imprisoned in Iran for over 3 years because he attended a demonstration against the Iranian government. It was a peaceful demonstration for freedom and democracy. There was a crackdown on all the political groups at that time. My brother, he was tortured. We were all subject to investigation and inspection and harassment. Our house was raided at least a couple of times by the U.S. By Iranian government. I did not go to any political. I did not go to the war. I didn't join the army. I was against war with Iraq, and I wanted peace for my country. They took me. They didn't let me to get to university, so I had no chance for education. For all these reasons, also I could not speak my thought. I was getting suffocated in my country because of all that. We didn't really feel safe. Also, something else I should tell you that Revolutionary Guards. We had some Revolutionary Guards in my street. They were always harassing us. They used to write anti-American, like "Death to America" slogans in the wall of our house. They knew that one of my brothers was in U.S., so they felt that we are pro-Western and pro-U.S. They used to say they used to write "Death to anti-revolution." So we were all subject to humiliation and everything else. So that's why after the war ended, I joined the army. I got my passport, and I got out of the country. I was not feeling safe, and I could not even breathe there anymore.
Did you participate in any freedom of expression or speech once here? Did you advocate for democracy in Iran here?
Yes, I mean, that was my whole intention, was to get here to be able to talk and speak my idea and for freedom and democracy. And it was my absolute right, which is protected under First Amendment, to get here. And I feel, even though I left my country, I felt for my compatriots back home. And I wanted them to be free. I felt that I can be a voice of my own people. That's why I attended a couple of demonstrations here in U.S., which was permitted and legal. And I will do, if I have to, I will do. It's absolute my right to practice my First Amendment right here.
What happened when you were detained in 2001?
Let me just go back a little bit. In 1999, we were arrested the first time. An immigration violation. My fake attorney was arrested, and he was sentenced. After 6 months, we got released without any due process. We got released with high bonds, which is unusual, because we didn't do anything wrong ourselves, and we don't have any criminal history or record. After 2001, unfortunately, that tragedy of September 11 happened. That was very heartbreaking for everybody. And I didn't know that I can be a casualty of post 9/11 myself. I'm a victim of 9/11 myself. I mean, the other casualties. I was going to my office. A white Ford car was following me, and I felt that somebody is following me. So they did stop me, and it was there were some FBI agents. They took me. They asked me to get out. They asked me if do you have weapon, ammunition? I said no, I'm a peaceful person. What's going on? They said you're getting arrested. I said why? I had my bond. I was going to my immigration courts. I have a valid work permit. I have no violation. They said no, you're a terrorist. We have to take you. So they took me to their car, and I remember they asked me about my brother, Mostafa, and I told him that he doesn't live with me. They said, no, let's go to your home. They took me to my home, and while when we arrived, they put a shotgun on my head, and they said that just ask your brother to get out. I told him he doesn't live with me. Go ahead, ask him to get out. We know he is here. So I was shouting and yelling at my brother. I mean, he was not there. I knew that Mostafa, please get out. They're gonna kill you. If you don't get out, they're gonna kill you. And meanwhile, I had a shotgun on my head, and it was very scary and horrible experience. So anyway, there was no answer. So they said they want to. So anyway, I opened the door, and they got in. They searched the house. No, there was nobody. They searched even the garage. They did, and he was not there. So anyway, I was taken to custody, and I spent 41 months in detention, 20 months in solitary confinement in Santa Ana jail, about a month with all gangbangers and criminals in county jail in Las Vegas, and about 20 months in San Pedro jail.
What were the conditions, and did you have access to legal or medical service?
The condition was, I mean, horrible. First of all, you have they arrest 4 brothers, and every day you are seeing your brothers suffering, and you are suffering with them too. It is the hardest thing to see your brothers are getting harassed, intimidated, or even beaten, and you cannot do anything. My brother Muhammad, he was beaten by immigration officer right in front of all cellmates and us, and we couldn't do anything. And another brother of mine, Mostafa, he had a panic attack, and he was begging and banging the door, please let me out. And they didn't. Finally they did, and they took him, instead of taking him to medical, they took him to another cell, a cold cell down there. My other brother, my brother Muhammad, again, he was beat. He had, and he also had panic attack because one of his cellie, he was a suicidal guy. He cut himself, and the blood was all over. All over the cell, and he was banging the door. Please let me out. This guy is killing himself. And finally, and he was shaking. He was really badly shaking, and they didn't do much for him either. The food was bad, especially in Santa Ana jail. It was horrible food. It was spoiled food. Everything was expired, and it was the lowest quality food I had ever seen. And sometimes we threw away the food in trash. We had I would say, medical, no medical access, really, not much. I lost my teeth there. I had depression. We all had depression. We got PTSD. The access to lawyers were difficult. The conversation with the lawyers were getting recorded, and especially in Santa Ana jail, I know they did that. And sometimes they didn't give us our documents to be prepared for the court because they wouldn't let us to have it on time. So for all these reasons, we didn't feel comfortable at all. It was horrible. I couldn't talk to my parents. It was for some months. It was so hard to get to talk to my parents, and it was very difficult for us the whole condition.
Thank you, Mohsen. President, I would like to ask you for a few minutes to finish my questions. Just 1 minute. We only have one question left.
Un minuto.
Thanks. The last question, Mohsen. When you were released, were you permitted to remain in the United States? What has your life been like since?
I got withholding of removal, so I can stay here. We had to go to doctor, psychiatrist, psychologist for over 2 years myself. I had no money. My reputation is all gone. I lost a lot of friends, clients, and even it's hard for me to date because my name is shows on the Google search as a terrorist, and it has to be cleared. So it's very tough for us altogether.
Thank you so much.
Muchas gracias. Quisiera hacer una corrección. Identifiqué al primer declarante como para la determinación del otro declarante. Así que Moshe es el que está ahora declarándonos, ¿verdad? ¿Es así?
It's Mosen. Yeah.
Mosen, para tenerlo presente, porque creo que le dije el nombre del hermano, si no me equivoco. Bien, quiero solicitarle al Estados Unidos si tiene a bien hacer algún interrogatorio al declarante, si así lo prevé. ¿No? Muy bien. Entonces, vamos a continuar con la participación entonces del segundo declarante. ¿Sí? Vamos a llamar ahora sí a
Mostafa.
la pregunta de la comisión, por eso decía, ¿sí hay? ¿Sí? Vamos, sí, para que sean las preguntas inmediatamente y después entonces convocamos al siguiente. Vamos a darle la palabra en este orden a la segunda vicepresidenta, Roberta Clark, si tiene algunas preguntas para el declarante.
Thank you very much, Vice President Esmeralda. Just a few questions. You talked about you were detained for 41 months.
Yes.
And can you give us the details of detention of your three brothers, and were they all held in the same facilities that you were held in?
Yes, ma'am. We all, most of the time, we were together in the same facility. All of us, we stayed in solitary confinement in Santa Ana jail for 20 months. 24 hours of lockdown. Only 1 or 2 hours they would let us to go out. I mean, for free time, 1 hour, 2 hours. Sometimes I remember at sometimes even to 48 hours lockdown. In Santa Ana, in Vegas also we were together. We all with criminals, gangbangers and everything else. And I was beaten up by a gangbanger in Santa Ana, in Las Vegas County Jail. And about 20 months also in San Pedro facility. Yes.
Yes, I just have two short questions.
Sure.
Were you given the reasons for your detention? That's one question. And the other question, what is your profession now? What was your profession then, and what is your profession now?
I've been a real estate agent since 1993. So it's my continuous profession since then. The reason for detention was I participated and my brothers also in some rallies against Iranian government, not U.S. government. It was pro-democratic rally for freedom of my country and my people. Basically, what the government says is that this is the whole core of their arguments in all proceeding is that participation in the rally creates material support, and that's why it caused it makes you to be a member of that organization, and thus you are a terrorist, and they equal participation in a free democratic rally to terrorism, which is I believe this is against fundamental rights of everybody. And I came to United States when I see that Lady Liberty up there, for me, it has a big meaning. It means that it means justice, it means freedom, it means law, and it means democracy. So that's why I came here. And I cannot believe that I got detained in U.S. for almost 4 years, 6 months the first time and 3.5 years the second time. And my other brother, one of my brothers, he got detained 1.5 years the first time and 3.5 years the second time. Like 5 years of his life. And we almost 4 years, because we just went to a rally against Iranian government. The violation, immigration violation that they brought it up, it was just an excuse. For any immigration violation, I had seen people, a family, let me tell you this is a very interesting case. A family of 3, husband, wife, and daughter, all of them, they got married, fake marriages, all of them, they got detained in immigration court. In a month, all of them, they got freed. I didn't even see the judge to present my case. I didn't falsify any information. My lawyer did falsify the information. They signed the falsified documents, not me. I didn't even have a fair hearing. And after our arrest, intimidation of our witness was intimidated. The government told us that you guys have FBI agent. Told us that, Your Honor, I want them to get detained. For them, it's safer to be here, because other people, I don't know, some people want to kill them, and I want them to cooperate with me. And that was the condition of the release, was for us to cooperate with him and probably become informant. And we did not want to cooperate because the groups or the organizations who are pro-democratic against Iranian government, we share the same values. I cannot lose my integrity and conscience.
Sí, vamos, para tener oportunidad de la participación de los demás comisionados, le paso la palabra a la comisionada Mantilla y después al comisionado.
Muchas gracias. Thank you so much. Good morning, Mr. Mohsen. I hear your story with very attention, and I have like a few questions. According to your story, you were expressing yourself, and because of that expression in this march, you were detained. So after you were released, did you ever participate in any other protest or march? This is first. Did you ever express? And the second thing is that it's hard to talk about reparation, I know, but if you could think about any way of reparation that you think that you deserve, what would you expect as a reparation? So these two things, please. Thank you.
Thank you. Sure. Yes, I did. As I mentioned, it is my absolute right to go to any demonstration, and I'm an advocate of freedom and democracy in my country. I did the last couple of demonstrations I went. It was in Los Angeles. It was for the life. For a lot of Iranians, they came to LA because we have a kind of semi-revolution. They had a semi-revolution last year in Iran. What they call the Woman Life Freedom movement. So I did. And I will do. If there is any more demonstrations, absolutely I will. And if they cannot arrest me, they should not arrest me anymore. I mean, it's so ridiculous that they take you they take your freedom because you want other people to be free. They take your freedom in USA. My request, genuinely, we have asked before through our lawyers, is our reputation is gone. I mean, the defamation was big. I mean, for me, even dating is difficult because people they go or even getting clients is difficult. They Google your name easily and they see you as a terrorist. What's going on? I want U.S. to give me an apology, a written apology. I heard somebody giving me a verbal apology, but that's not enough. It doesn't solve my problem. I didn't hurt you guys. You hurt me. And second, I didn't have a fair hearing. My status is, I don't have a status, good status. It's the withholding of removal. Anytime the government change, I cannot do much here. I want a fair hearing. I want an adjustment of status. Also, I need them to offer a remedy for me. I lost 4 years of my life here, combined with my brothers. Over 14, 15, 16 years of life is lost. Useful youth life.
Bien, gracias, comisionada. Comisionado Caballero.
Gracias. Thank you very much.
Thank you.
I don't know how clear this. What is your immigration status right now? And if you have been involved in a conflict with the state about this point recently? These two questions.
What was your second question? I'm sorry.
The second question is if you have involved in a conflict with the states about your immigration status, specifically.
You mean contact with other states?
No, with the states, with the United States, with the state.
Oh, I see. I'm sorry. My status is withholding of removal. It means that they cannot deport me. I'm deportable under their law, but I cannot stay here for long. I mean, I don't have green card. I don't have anything on hand. And also, I got protection under CAT, Convention Against Torture. It means that if I get to Iran, I can get tortured. So I don't really have a solid status. I cannot go out of my country. I lost my parents 4 or 5 years ago, and I couldn't see them. I didn't see my parents for 25 years. I wanted to be with my parents when they die. I wanted to see them, meet them, kiss them, hug them. I couldn't. My dad passed away. I wanted, honestly, my brothers are here. I seriously wanted my dad to die in my own hand, not even in hospital, in my lab. Or my mom, same. My mom was my friend. I lost my mom 4 years ago, and she didn't meet us. My older brother, he's been here for 40 years. They didn't for 42 years. They didn't see each other. We cannot go out. We could not go to my mom and dad several times. They asked us why. Go talk to a lawyer, do something. I can't do much, Mom. I cannot go out of the country. Can we see you in Turkey? Can we see in Spain, France? No, I can't. Why? And my dad, when we got released, let me tell you this. They asked me, my dad, when I told him that I'm for 3.5 years, they didn't know we are in detention. We didn't tell them. 4 brothers. They took 4 brothers together to break him down. They wanted us to cooperate for what? To cooperate against other freedom seekers that we share the same values. So I don't have any status. I lost my parents without seeing them. I just sometimes some of my friends they send me a picture of their graves. That's it. And U.S. has not helped us so far. I mean, we are under probation, sir. We have been under probation for 15, 17, 18 years. We had to call them weekly after we got out, even though we are not criminal. We had to call them weekly to say that we are here for probation. The officers, they used to come to our home once a month, and then it becomes 6 months. Even now, up to now, once a year we have to go and report that we are here. We are not escaping. Where can I go? I need a status. I don't have any status. I lost a lot of money. I lost all my reputation, 4 years of life. And I hope it doesn't happen to other people. I hope so. And the material support, that this word that they could use in their immigration status, immigration arguments, material support, attending a rally is a material support for this organization. This organization had over 200 congressmen and senators. They supported them. Mr. John Ashcroft, he was supporting the organization. We were arrested at the time. We were arrested at the time that Mr. John Ashcroft, he was head of Justice Department, and he was supporting that organization.
Yes. Thank you very much. I appreciate your answer. We have to finish. Thank you very much.
Gracias, disculpen. Bueno, muchas gracias. Yo no voy a hacer preguntas por asuntos de tiempo, agradeciéndole al declarante su participación. Paso ahora sí a llamar al segundo declarante, ahora sí el señor Moshe, no, es es que como invertí el orden. Mostafa, ahora sí, yeah. Mostafa Seyed, muchas gracias. ¿Y ahora sí? Muy bien. Disculpe, sí. Vamos entonces a escuchar el testimonio de la presunta víctima, Mostafa Seyed, quien declarará sobre su experiencia en la detención, las presuntas violaciones a la libertad de expresión, el debido proceso, el impacto de esto en su vida como consecuencia de las presuntas violaciones de los derechos humanos y las reparaciones que considera necesarias. La parte peticionaria tendrá los 10 minutos para realizar el interrogatorio. Sí les vamos a pedir que el declarante tenga la precisión del tiempo, de manera que podamos entonces la comisión, el Estado y la comisión hacer el interrogatorio que corresponde.
Thank you very much. Mostafa, did you participate in any freedom of expression or speech once here in the United States?
Yes, I have. I have been in several rallies, pro-democracy rallies sponsored by NCRI in this country, including the one in Denver in 1997.
Thank you. What happened when you were detained in 2001?
In 2001, I received a phone call from my attorney that you should give in to FBI, and FBI is looking for you. They want to detain you again. And I gave my address and everything, and they came there with all guns and everything on my head, as usual. It's normal for them, I guess. And they arrested me and detained me, and they took me to downtown for processing. And at that time, they put me in a room that was about 20 feet by 15 feet. There were about 150 people there, and there were 2 toilets there. One was always clogged, and it smells all over this. And we were begging the guard to open the door and let us have some air. They would not even do that. So they used to keep us there for all day, and at night time they take us to San Pedro jail. And San Pedro jail, there were no bed at the time. They didn't have a bed, so they had some plastic temporary beds. They put those in restrooms, in the toilets. And they asked us to go and sleep there, and we used to sleep there. And at the next day, they used to do the same thing, going to downtown again and being in that same room again. So this was going on for some times. And after that, we actually went to transfer to Santa Ana jail. It's a different jail. And we were there for some time, for a long time. And in that particular jail, each cell, there were 2 beds on each cell. And we were locked on most of the time. I mean, 24 hours and sometimes for 3-4 days even, we were locked down. And we were begging to be out for an hour or two, and sometimes they would let us out for an hour or two. But beside that, it was really hellish life for us. It was so stressful, and we went through so much stress and everything. Basically, that was that jail, and at some point they took us to Las Vegas jail as well, and in Las Vegas jails, it was really bad. All gang members, killers, and bank robbers, and all those people were there, and so we were basically mixed with criminals all the time. In all these three jails, they all were rapists, criminals, bad people. I do recall in San Pedro jail, I asked that I didn't want to sleep next to a gang member. They said, no, you cannot do that. You have to sleep right here. And then I said, I don't feel comfortable. These are gang members. These are killers. I just don't feel safe. And they told me that you have to do. I said, is there any way that I can go to segregation? They said, no, you have to do something bad in order to go there. I said, what should I do? I said, well, you have to go and beat somebody. So in order to go to basically to segregation, I thought it's safer, personally, for my life. They said, no, you cannot do that. You have to be this and that. And the situation was very bad. I personally am vegetarian, and I lost at least 20-some pounds while I was in jail, and they were not giving the right food to us. And also one side of our story was my mom and dad back home in my country. We used to call them once every 2 weeks, and when we were detained, they didn't give us the chance to call them for at least 2 months or so. And my mom was thought that something has happened to us, and basically she went to hospital, and she was in a really bad shape. So we were dealing with our folks back home, our life here in jail, and meanwhile we used to pay our bills and all these things on time. We were trying to pay all these things as well.
Thank you. When you were released, were you permitted to remain in the United States?
I had a temporary status. We all had a temporary status under Convention Against Torture, CAT. Yes, we could stay as long as government of Iran was back home, was in existence. Yes, we could stay here. Yes.
Did you have a fair hearing in the immigration proceeding regarding the revocation of the bond and the grant of asylum?
Yes, our bond revocation, it did happen when we had a bond hearing. We didn't have a fair hearing. All four of us were bundled in one hearing. And so it was not an individual hearing for our bond. So, and FBI agent Castillo, he produced a document, and our name was there, and he called this LSL form, and he said that this shows that you guys are a member of a terrorist organization, basically, and he asked the judge to not to give us bond and keep us in jail as long as possible, because he was asking us to cooperate with him on a case that he had against some people that were against government of my country, basically, and yeah, and he also said that attending a rally creates material support for that group. Attending a rally create material support for that group.
Thank you. What has your life been like since?
When we got out of jail, it was hell, really. Our life was completely upside down. We were drained, psychologically destroyed. We used to go at least for 3 years to different psychologists and doctors, and also we lost. I mean, everything was expired. My real estate license was expired. My DMV IDs were expired, and we had to go through all these things and renew everything. And when I got in touch with my clients, they all was very afraid. They all were very afraid to talk to me. They said that you're a terrorist. They say we don't feel comfortable. So they really destroyed our life. Our life was completely destroyed by U.S. government for 3.5 years. A stressful life, a stressful day, night, thinking what's going on, what should we do with my mom and my dad, what the heck to do this here, because we didn't let my parents know that we were in jail all along.
We finished. Thank you.
Muchísimas gracias. Gracias al declarante.
Thank you.
Quisiera hacer el declarar en este momento que existe el principio del Estado de reservar su posibilidad, su voluntad de interrogar al testigo. Como se dio en el primer testigo, quisiera tener la posición del Estado en este tema.
No, thank you. Again, we decline to ask any questions at
Muy
this
bien.
time. Thank you.
Bueno, no, muchísimas gracias. Muy bien. ¿Comienza Roberta? Sí. No, sí. Bueno, le vamos a dar la palabra ahora a la comisión y comenzamos con la comisionada Roberta.
Just one short question. You said, sir, as you began your testimony, you said that you were detained again in 2001. Were you detained before that?
Yes, we all were detained the first time in March of 1999, and I do recall that a special agent and the FBI agent, they both told us that they would send us to Iran as a present for President Khatami back home in my country. So they were trying to send us back home as a present to Khatami. So this clearly shows that our case was politically motivated since the inception of it. So and they also told us that they use word F, you are fucking mujahid, and you will be sent to Iran as a present to President Khatami, because it was a Persian, it actually was, March is a Persian New Year. So they were trying to send us as a present to Khatami for the New Year, basically. And we actually were in detention, in jail for 6 months. The same situation that I explained before, that they used to take us to this bunkers. They call it bunker. It's a room around 20 feet by 15 feet. And we were there. 150 people, sometimes 200 people were there, and no air, a smell everywhere. I mean, so they used to keep us there for weeks, and at night time they take us. They used to take us to San Pedro jail. Again, the same problem. Bathrooms. They put us in bathroom. They with this bed that they had, and then the next day they used to take us again, and then at one point they kept us in San Pedro jail. And I'm sorry, we actually the first time we were in Lancaster jail. We were in Lancaster jail for a long time. So we were detained for 6 months ourselves. Three of us. Muhammad was in jail for a year and a half. So, and we had the same stressful life. And my parents, again, was the issue here. How should we get in touch with them? And so on.
Gracias. Comisionada Mantilla.
Muchas gracias, Presidenta. Thank you, Mr. Mostafa. Thank you very much for your testimony. Two short questions, please, to be very precise in the answer. First of all, you mentioned that you have this psychological impact, depression. And besides that, you have other impact in your physical health, that your body, your behavior change, and these things. And the other thing is that if you have the opportunity, I know that it's very difficult to talk about reparation after all what you suffer. So, but if you could ask for a reparation, what would you ask now? Thank you.
In regards to, I mean, I have some stuttering, as you can hear me, and this did happen in 1999. The first arrest that I had, and we all had, and the way they attacked our home, the way they acted toward us, banging our doors from back and forth through the back side and front side, dang, open. It was about 5-6 a.m. and I woke up and I was fainted. I was just about fainting, and they came inside with gun at our head. You are terrorists, this and that. Where is your guns and explosive? I said, we have no guns and explosive here. So, and then they search everywhere for guns and explosive and things like that. So from the beginning, from that point, I started stuttering, and my life really got upside down from that time. And life in jail, 3.5 years of precious life the second time, and 6 months about my precious life and our precious life the first time. There has to be a remedy for that. It's not fair to us. And we went to different courts in this country. We went to Ninth Circuit, to different courts here. They informed us that they could not hear our case because we are not a U.S. citizen. And beside that, they informed us that government has immunity in this country, and they can do anything they want, basically. So in a way, they told us that government is absolute here. There is nobody can do anything about it. They are absolute. They are the king. The king, not like you. They're absolute. So basically, and for that, we would like to have a just remedy for what we have gone through in our life and so on. And as I don't know if Mohsen explained to you or not, we had a key witness in our immigration case that was threatened when he came to court. he was threatened not to be a witness. So he left. If he were to become a witness, he was told that he would be charged and put in jail again. So our key witness for asylum, he left the court. So and so on. Thank you.
Gracias. El comisionado Caballero no va a hacer preguntas. Bien, voy a hacer unas preguntas, dos puntos muy concretos. Cuando usted llega a Estados Unidos, saliendo de su país por razones de protección, de seguridad, la respuesta de Estados Unidos, ¿cuál fue? De acuerdo a su percepción, los años que tenía, ¿cómo evaluó usted esa respuesta que Estados Unidos le daba para entrar al país? ¿Cómo? No sé si comprende la pregunta en la traducción.
Yes.
Ajá.
Yes, ma'am. Actually, I came in this to this country in January of 1978. It was before a revolution, and I came here as a student, and I did have a visa here. And while I was in this country, I did attend rallies against the mullahs that are in power right now. So I turned against them basically. But of course, in this country, I was very happy to be here, because I thought here we have it is a center of the democracy and so on. So yeah, that's basically.
Y en esa línea de esa consideración, el centro del derecho, de la libertad, ¿cuándo cambia esa situación en su vida y las razones que tenía de acuerdo a lo que usted sabía, lo que usted conocía de la posición ahora del Estado, del gobierno de Estados Unidos, para cambiar de posición en el trato y todas las situaciones que usted ha planteado como infierno? Esa fue la palabra que usted usó. ¿Qué representó para usted ese cambio? ¿Qué explicación podía usted encontrar o qué argumentación usted preparó en su mente para no entender, porque no había por qué entender, sino estar viviendo lo que vivía, el cambio que se dio? ¿Cuál cree usted que fue el motivo y toda la situación que transforma ese pensamiento del Estado como el derecho hecho verdad en todo su sentido? ¿Comprendió mi pregunta?
Yes. Thank you. Yes, I mean, from the beginning, that's what I explained, that I was under the impression that this country is for democracy and everything, and we have these rights.
El cambio.
Rights to attend rallies and read different books and different opinions, so and so. But what happened in our case was the one that changed my mind about it. What really happened in our case, it was I just couldn't believe it, that this is going on in this country, and I'm sitting in jail, and they're asking me to cooperate, and they're asking me attending a rally creates material support. and so on. So actually, it happened. The change happened. What happened to us basically changed my mind about this whole issue.
Bueno, muchas gracias.
Thank
Yo
you so much.
quisiera ahora, agradecemos su declaración y vamos a continuar entonces escuchando el alegato de las partes. La parte peticionaria tendrá 15 minutos para presentarlos y luego el Estado, si así lo considera. Le doy la palabra.
Honorable Commissioners, members of the Secretariat, thank you for convening this hearing. Thank you as well for providing a space where Mohsen, Mostafa, and Mohammed can finally be heard after years of being denied a hearing in the United States. The Mirmehdi brothers are here today because of the enduring effects of the pervasive discrimination against non-citizen Muslim men of Middle Eastern, African, and South Asian descent post 9/11. And the systematic closing of courthouse doors to immigrants seeking to vindicate their rights through the judicial system. I will discuss how the brothers had their bond revoked after 9/11 based upon their political expression and ethnic origin. Then we will discuss how they were denied proper due process based on their immigration status. And then we will discuss the reparations the brothers seek. After 9/11, the United States government embarked on a massive investigative campaign. As a result of this campaign, the FBI arrested 738 non-citizens between September 11th, 2001 and August 6th, 2002, 97% of whom were Middle Eastern, South Asian, or of African descent. Nearly all of these detainees were found to have no connection to terror groups. The Mirmehdis, who are in front of you today, were caught in this unjustified sweep. The Mirmehdis came to America because of persecution for their political expression in Iran. In the United States, the Mirmehdis became real estate agents in the greater Los Angeles area and continued expressing support for a democratic Iran. They saw America, as it is so often portrayed in the media, a beacon for the open expression of ideas, and understandably believed that they finally lived in a country where this expression would be protected. They attended several pro-democracy rallies during the mid-1990s, including a June 20th, 1997 demonstration in Denver, organized by the National Council of Resistance of Iran, the NCRI. While only 2 of the brothers were able to attend the rally, all 4 originally planned on attending. After 9/11, the Mirmehdis were caught in a dragnet that primarily targeted Middle Eastern, South Asian, and African men. The government detained the brothers and sought to revoke their bond. The main piece of evidence used against them was a travel log for the 1997 Denver rally. The FBI took the log out of context, and it became the crucial piece of evidence used to revoke the brothers' bond and arbitrarily detain them for 3.5 years. The FBI argued this was not a travel log, but a cell form that demonstrated the Mirmehdis were supporters of the MEK, an Iranian opposition group listed by the United States as a terror organization in 1997 and delisted in 2012. Dr. Mehran Kamrava, an expert in Farsi and regional politics, submitted an affidavit today for the hearing, confirming that the FBI mistranslated the form and it is simply a travel log. The date of the NCRI event even appears on the top of the form. In reality, the brothers were never members of the MEK and simply cared about promoting democracy and human rights in their country of origin. The U.S. detained the Mirmehdis for 41 months, using evidence that only existed because of their political expression. The list of names, given that it is incontrovertibly related to attendance at a pro-democracy demonstration, implicates the brothers' rights to freedom of expression, assembly, and association. The U.S. violated the Mirmehdi's Article 4 right to freedom of expression by revoking their bond based on evidence related to their political speech. The Commission's jurisprudence prohibits discrimination and detention based on freedom of expression. In Bisset v. Cuba, for example, the Commission found a violation of the petitioner's Article 4 rights when they were arrested for protected political speech. The United States' actions in this case are even more egregious than Bissett because the speech here was not even directed at the United States, and it was endorsed by members of Congress at the time, many of whom attended the rally in Denver in 1997. The Commission has also emphasized that the rights to freely assemble and associate are closely related to freedom of expression. In Huilca-Texe v. Peru, the court found that the right to assemble and associate included the pursuit of a legitimate goal without pressure or interference from public authorities. The United States violated the Mirmehdi's rights to assembly and association by detaining the brothers for participating in a peaceful assembly with fellow supporters of a legitimate political cause, democracy in Iran. 4 brothers escaped political persecution in their home country and learned that their human rights were still every bit as illusory in the United States. I'll now turn it over to my colleague, Kat Washington, to discuss the deprivations of due process that the Mirmehdi suffered.
Thank you. As my colleague stated, the Mirmehdi brothers have endured significant due process violations, largely stemming from discriminatory post-9/11 policies, the use of false evidence and testimony in their bond revocation hearing, and the denial of any effective judicial remedy. The American Declaration and Inter-American case law both prohibit discrimination and guarantee rights for all, even for non-citizens, and especially for protected political activity. In both Frere, Missouri, and Biscuit, the Commission found that a state cannot make distinctions in treatment that are disproportionate to state goals, or that are discriminatory. Both independent NGOs and the U.S. government have found that the United States post-9/11 immigration, national security, and anti-terrorism policies were based on discriminatory religious and racial profiling. The U.S. consistently denied the Mirmehdi's rights under the same discriminatory framework. The timing of their arrest indicates that the U.S. used the LA cell form as a pretext for arresting them. In actuality, they were arrested due to their Iranian nationality, as part of a systematic profiling of Middle Eastern immigrants after 9/11, culminating in a denial of the brothers' rights under Articles 2 and 17. The brothers also endured violations of their right to an impartial hearing. In Mortlock v. U.S., the Commission recognized that an individual shall not be denied due process protections in immigration proceedings. In addition, in Oliveros Munoz v. Venezuela, the Commission established that a state's duty to fully and impartially investigate its human rights abuses is obligatory. It cannot be just a mere formality preordained to be ineffective. The U.S. utilized blatantly false and misconstrued evidence to justify the revocation of the brothers' bond, including the distortion and falsification of several aspects of the LA cell form. Moreover, the decision to revoke the brothers' bond was also tainted by witness intimidation. In Telugus v. U.S., this commission found that the use of witness statements known to be false amounts to a denial of justice, contrary to due process standards. Baran Tabatabai, a witness that corroborated the FBI's version of events, recanted his testimony on 2 separate occasions. Tabatabai was also prepared to testify in favor of the brothers during Mohammed's bond hearing, but Agent Castillo threatened him prior to this hearing. Castillo's threats persuaded Tabatabai not to testify. By basing their case against the petitioners on falsified evidence and recanted testimony, the United States violated the Mirmehdi's right to due process and a fair trial. After release from detention, the brothers filed a civil rights lawsuit in the U.S. District Court, alleging false imprisonment, unlawful detention, witness intimidation, and conspiracy to violate civil rights. However, the District Court dismissed all of their claims. The Ninth Circuit Court of Appeals affirmed this dismissal on the grounds that non-citizens do not have an ability commensurate with that of citizens to seek justice for violations of their rights through the United States judicial system. The Court of Appeals also found that the brothers had an effective remedy in their immigration proceedings, despite the fact that it is not possible to bring a wrongful detention claim in U.S. immigration court. In Amezian v. U.S., this commission held that the denial of a remedy is an independent violation of due process rights, and that where a petitioner was unable to access any effective civil remedy for 16 years, every indication of domestic law is that such remedy is not meant to exist. The Commission also found that there is an inalienable right to know the truth about past events so as to prevent recurrence. Likewise, here, for over 20 years, the United States has systematically deprived the Mirmehdis of any effective judicial remedy for their wrongful arrest and detention. More fundamentally, the Mirmehdis have had no chance to expose the truth, motives, and circumstances behind their unfounded detention. We thank you today for providing Mostafa, Mohammed, Mohsen, and Mostafa the chance to have their voices heard, an opportunity that they were denied in U.S. court. I will now turn the discussion to my colleague, Tessa Baser, to discuss the long-term consequences of the brothers' detention, along with what they hope to achieve by bringing this case.
Thank you. The petitioners have suffered consequences to their health, professional lives, and personal lives because of their arbitrary arrest and detention. Over 20 years after their initial arrest, the Mirmehdis have yet to receive reparations or compensation for their wrongful detention and the lack of due process that they endured. The Mirmehdis continue to suffer long-term mental health effects stemming from their detention, such as frequent nightmares. Mostafa has constant, recurrent traumatic memories. Mohammed has recurrent anxiety when he sees things that remind him of his wrongful detention, such as white vans and plastic silverware. He remains in constant fear of the FBI's watchful eye. He also re-experiences trauma whenever he has to interact with immigration officials, which is a necessary and regular occurrence due to his lack of permanent status. Mohsen also experiences recurrent fear and anxiety when seeing unfamiliar cars and people, and remains constantly nervous that he is being watched by government officials. Mostafa experiences sudden flashbacks, anxiety, and depression. The brothers have adequately and aptly testified today as to the reputational harms they've suffered. They were unable to work for 3.5 years. After they were released, their client lists were decimated. As they've testified, the United States' false accusations continue to affect them to this day. These false accusations against them damaged their reputation in both Los Angeles and Iran, because they were widely publicized in both national and international media. In Amezian, this commission held that a remedy for a human rights violation must be sufficient to obtain reparation for the harms caused. In Maldonado Rodriguez, the commission held that states are required to provide integral reparations for human rights violations. We urge the commission to recommend that the Mirmehdis receive compensation, comprehensive reparations, and remediation for the violations they suffered as a result of state action. These reparations must include monetary compensation for the pain and suffering the Mirmehdis endured while detained, and the hardship the brothers incurred due to their combined loss of income, clients, and property. In Amezian, the Commission recommended that the petitioner, who was detained without charge due to alleged ties to terrorism, be compensated both for his wrongful detention and for the lasting psychological harm that the actions of state officials caused. In Suresh v. Canada, the Commission recommended that the state provide reparations to the petitioner who was wrongfully detained and denied permanent status because of the government's false belief of his involvement with foreign terrorism. In Amezian, the Commission also recommended that the state provide a public statement by a high-ranking official making clear that the petitioner is not and never was a terrorist. Here, reparations must include formal recognition of the state's wrongdoing through an official apology by high-level officials and the state officials who were involved in perpetrating these harms. The reparations should also include an adjustment of the Mirmehdi's immigration status to that of asylum. Due to the lack of due process they faced in the immigration proceedings, the brothers need to have the rights and stability coterminous with that of a more permanent immigration status. Reparations must also include the adoption of measures aimed at clarifying the facts of their arrest and detention. They have not yet had the chance to expose the motives and circumstances behind the state abuse. In Los Ventura v. U.S., the Commission urged the United States to review trials and sentences according to the fair trial and due process guarantees in the American Declaration. They should do the same here. This could include an investigation aimed at evaluating the facts of the petitioner's arbitrary arrest and detention according to inter-American standards. Finally, the United States must formally review its laws, policies, and practices to ensure that additional persons are not deprived of fundamental rights based on their immigration status or national origin. The U.S. should train its officials, including those in the judiciary, according to international standards. In Ferrer Mazorra, the Commission urged the United States to ensure all rights in the American Declaration be fully afforded to detained non-citizens. Distressingly, the Commission made this recommendation in 2000, before the Mirmehdi's wrongful detention even occurred. To this day, the United States continues to violate the rights of non-citizens held in detention. The United States must take measures now to ensure the non-repetition of these violations.
Muchísimas gracias. Vamos inmediatamente, le preguntamos al Estado si va a hacer uso del tiempo para hacer sus alegatos.
Sí.
¿Sí?
Gracias, buenos
Muy bien.
días. Good morning. Thank you first to the distinguished commissioners, secretariat colleagues, to the Mirmehdi family for being here today, to the two brothers who shared your experiences. My name is Thomas Hastings. I'm honored to be here in my capacity as the Deputy Permanent Representative of the U.S. Mission to the Organization of American States. I'd first like to reiterate my government's support for the Commission's important work of monitoring human rights situations and shedding light on these issues both here in the United States and throughout the Western Hemisphere. We also acknowledge that petitioners before the Commission play an important role in advocating for the promotion and protection of human rights by all OAS member states. And to that end, we'd like to thank the petitioners who are participating today for sharing your testimony. As an initial matter, the United States maintains its position that this case is inadmissible before this body. However, we are here to listen to the petitioners on this matter and receive any observations which are raised in today's hearing by the Commission. I'm pleased to be joined here today by colleagues from the U.S. Department of State and the U.S. Department of Homeland Security, who will provide further U.S. statements on this matter. And I'd like to first turn to my colleague Sarah Hunter from the Department of State's Office of Legal Advisor to begin.
Thank you. For context, I'll begin with a brief history. The petitioners arrived in the United States between the years of 1978 and 1993. For years, they lived and worked here without legal immigration status. Eventually, they all applied for asylum in 1998 with the assistance of an individual who was later convicted of filing false claims. Petitioners admitted that they filed fraudulent applications and obtained fraudulent identification. This included falsifying dates of entry to satisfy the general requirement that you apply for asylum within 1 year of arriving to the United States. In 1999, they were arrested for immigration violations but released on bond that same year. Their immigration case progressed, but in early 2001, the federal government searched an MEK safe house and uncovered a document containing the names of petitioners, the LA cell form. An FBI translator described this document as a list of affiliates of the MEK, then designated as a foreign terrorist organization by the U.S. Department of State. In light of this development, as well as testimony by an FBI agent who was in touch with a confidential informant, and other information, the government revoked bond for the petitioners in October 2001. An immigration judge upheld the bond revocation. That decision was explicitly not based on the LA cell form alone. Petitioners filed habeas petitions regarding their detention, which were held by the Board of Immigration Appeals and the U.S. District Court. In 2002, they were granted withholding of removal, but denied asylum given the untimely filing date. Moshan and Mohammed appealed to the Court of Appeal, which remanded on the bond determination but upheld the asylum denial. Ultimately, all of the petitioners were released from detention before the district court rendered a decision. Petitioners also filed a civil tort claim. That claim was in part settled, and the remainder of that claim was dismissed. That dismissal was affirmed. What I hope to illustrate with this review is the due process the petitioners received. Their assertions were carefully considered in several forums. The United States reiterates that petitioners settled their civil case and received monetary compensation. That settlement precludes review here. Although petitioners may not be satisfied with the result, they have received effective remedies. They were given the chance to appeal various decisions, were ultimately granted withholding of removal, received monetary compensation, and released from detention. As both the Commission and the Inter-American Court have stated on numerous occasions, these international human rights bodies are set up to work as complements to domestic courts and processes. The Commission has explained that under the fourth instance formula, that it lacks jurisdictions to substitute its judgment for that of the national courts on matters that involve the interpretation and explanation of domestic law or the evaluation of the facts. To this end, the Commission's role is not to sit in review of domestic forums. The petitioners have had ample opportunity to make these claims and did so. As we stated in our briefs, petitioners have also failed to exhaust all available domestic remedies regarding their bond determinations and asylum claims. Accordingly, the United States urges the Commission to reconsider its admissibility decision, allowable under the plain reading of Article 34, which notes that not only petitions but cases may be found inadmissible. Petitioners are also unable to establish any violation of the American Declaration. The American Declaration recognizes an individual's ability to access judicial remedies, but it does not preordain the outcome of those remedies. That petitioners did not prevail in their challenge before U.S. administrative bodies and courts does not and cannot mean that they were denied access to judicial remedies under the meaning of Articles 18 and 26. Despite their contrary claims, they were not arbitrarily detained. They were detained because they violated immigration laws, and there was evidence connecting them to a group on the Foreign Terrorist Organization list. Their nationality and political activity were not factors in their detention. Their potential relationship with a terrorist organization was. The petitioners re-raise arguments they made domestically about the allegedly falsified evidence that led to their bond being revoked. Multiple administrative bodies and courts heard this evidence. And their brief is replete with claims that the government agents involved in the case knowingly presented false information, but they have presented no facts to substantiate that claim then or now. Moreover, Article 33 of the Declaration recognizes that the duty of every person to obey the law and other legitimate commands of the authorities of his country and those of the country in which he may be. Non-nationals are bound to respect the state's immigration laws and may be subject to various measures, including detention, as appropriate when they fail to obey the law. Immigration detention, provided it is employed in a manner consistent with the state's international human rights obligation, is permitted under international law. Overall, petitioners have failed to establish facts to support any violation of the American Declaration. Finally, the United States has consistently maintained that the Commission's recommendations are not binding on the United States. The expansive relief that petitioners request goes far beyond the Commission's remedial capabilities. Let me now turn to our colleagues from the U.S. Department of Homeland Security for their statements.
Distinguished commissioners, petitioners, representatives, secretariat staff, and colleagues, on behalf of the Department of Homeland Security, or DHS, I welcome the opportunity to participate in today's hearing. My name is Scott Schuchart. I'm counselor to the director at U.S. Immigration and Customs Enforcement, or ICE, which is a component within DHS. First, I want to share with the Commission that the DHS Office of Inspector General, OIG, and the DHS Office for Civil Rights and Civil Liberties, CRCL, as well as the ICE Office of Professional Responsibility, OPR, all reviewed allegations that Mohammed Mirmehdi was mistreated by an ICE detention officer in ICE custody on March 5th, 2005. And as was shared with him in a letter from CRCL dated March 27th of 2008, the OIG's independent investigation, which included interviewing multiple witnesses, did not substantiate those allegations. Following the incident, ICE also notified both the Civil Rights Section of the United States Attorney's Office in Los Angeles and the Civil Rights Division of the U.S. Department of Justice about the incident, and both declined to prosecute. Second, I want to discuss ICE detention and bond proceedings. Prior to obtaining a final order of removal, ICE detains individuals where ICE is prohibited by law from releasing them, or where the facts of the case reflect that the individual poses a danger to persons or property, or where it's determined that no amount of bond or conditions would be sufficient to ensure the individual's appearance at future immigration proceedings or for removal. As happened in the petitioner's case, non-citizens may challenge a determination of whether they are bond eligible, and an adverse bond decision by an immigration judge may be appealed to the Board of Immigration Appeals. The federal district courts also have jurisdiction to consider challenges to prolonged civil immigration detention in the context of a petition for writ of habeas corpus. Finally, I want to highlight ICE's current detention standards, which are designed to ensure that non-citizens in ICE's custody are treated humanely and with respect, protected from harm, provided access to necessary medical and mental health care, and able to access materials and individuals who may represent them or assist them with their immigration cases. ICE has updated and revised its detention standards since the petitioner's period of detention. For example, ICE's performance-based national detention standards, first issued in 2008, were most recently revised in 2016, and the separate national detention standards, which apply to certain facilities, were first issued in 2000 and revised most recently in 2019. ICE's detention standards now establish minimum conditions of detention for detained non-citizens with respect to environmental health and safety, detainee non-citizen care, access to legal resources and consular officials, recreation activities, grievance processes to address complaints and concerns about conditions of confinement, and a number of other issues. These standards are designed to ensure humane conditions tailored to the needs of the ICE detained non-citizen population, consistent with the civil rather than penal purpose of immigration detention. And now I will turn it over to my colleague Monica Burke to talk about detention oversight.
Distinguished commissioners, petitioners, secretariat staff, and colleagues, it is an honor to appear before you today on behalf of ICE Enforcement and Removal Operations, or ERO. My name is Monica Burke, and I am the Assistant Director of the Custody Management Division within ICE ERO. I will provide information about ICE detention oversight, particularly updates that have occurred since the petitioners were detained in the early 2000s. This includes major changes since 2005 within ICE ERO Custody Management Division and the ICE Office of Professional Responsibility, as well as the creation of the ERO Contact Center of Operations and the DHS Office of the Immigration Detention Ombudsman. DHS meets its constitutional and statutory mandates, which are consistent with international human rights standards, by confining non-citizens in detention facilities that are safe, humane, and appropriately secure, and by implementing or mandating training requirements for all of its law enforcement personnel and detention staff. DHS is also responsible for monitoring performance and investigating alleged misconduct wherever warranted. Notably, I would also like to mention that most of our facilities that house the majority of our population are dedicated facilities where we house non-citizens separate and apart from other populations. We do use other types of facilities, but that is the vast majority of our population is detained in dedicated facilities, and they are separate from, again, other populations. I'd also like to note that we do allow protective custody, so we have individuals can be in special housing for protective custody reasons, not just for disciplinary segregation. The ICE ERO Custody Management Division provides policy and oversight for the administrative custody of ICE's highly transient and diverse population. ICE ERO employs more than 32 on-site federal detention service managers at key ICE detention facilities to monitor and inspect operations daily to ensure safe, secure, and humane conditions of confinement. The ICE Office of Professional Responsibility Inspections Division is responsible for the objective review of ICE offices and programs by assessing their compliance with federal law, applicable policies and procedures, and the agency's own detention standards. ICE OPR's Office of Detention Oversight conducts annual inspections of ICE facilities depending on how many non-citizens are detained there and for how long. These inspections assess facility compliance with ICE detention standards. The ERO Contact Center of Operations supports the ICE Detention Reporting and Information Line, or DRIL, a toll-free service that provides a direct channel for detained individuals, agency stakeholders, and the public to communicate with ICE to answer detention-related questions and resolve concerns. Concerns related to employee and contractor conduct may be submitted to ICE OPR, where they are reviewed by ICE OPR and the DHS Office of Inspector General. In 2019, Congress created the DHS Office of the Immigration Detention Ombudsman, or OIDO, which is the new office that oversees immigration detention. OIDO assists individuals with complaints about potential violations of immigration detention standards or misconduct by DHS or contract personnel, and includes conducting announced and unannounced inspection, and serves as an independent office to review and resolve problems. Additional layers of oversight are undertaken through site visits, investigations and audits from the ICE Health Service Corps, the U.S. Government Accountability Office, CRCL, and the U.S. Department of Labor, among others. These multiple channels of oversight enable ICE to provide and maintain a high standard of care for the detained population. As relevant to this case specifically, ICE no longer uses the facilities where the petitioners were housed. Specifically, those facilities are the San Pedro Service Processing Center, the Santa Ana County Jail, the Mira Loma Correction Center, and the Las Vegas City Jail. Finally, we understand from their petition that petitioners may be interested in conducting their yearly check-ins with ICE at a location other than the Los Angeles field office. ICE is amenable to having them report to a different location. We can follow up with petitioners and their advocates after this hearing, or their petitioners and advocates can reach out using the email address losangeles.outreach@ice.dhs.gov, or go online to www.ice.gov/check-in for more information about rescheduling a time and place for ICE check-ins. Thank you very much.
¿Concluyeron? Sí, muy bien, muchas gracias. Le pregunto a los peticionarios si van a hacer uso del derecho a dúplica por 5 minutos.
Thank you. To begin, I'd like to note that the brothers' claims were related to the wrongful imprisonment were already declared admissible by the Commission, so any arguments relating to admissibility are moot in this proceeding. Next, I'd like to turn to the allegations regarding
Más despacio para sí, por favor.
The allegations regarding their immigration litigation. The statute of limitations requiring immigrants to bring an asylum claim within 1 year was not in place until 1996. As we've noted, all the brothers entered the United States prior to that period. Therefore, when they entered the United States, this requirement was not in place. The brothers have testified today about their desire and their attempts to bring witnesses on their behalf to their bond proceedings. This witness was intimidated by FBI agent Christopher Castillo and threatened with arrest and detention if he testified on the brothers' behalf. Likewise, the brothers attempted to bring evidence of their innocence in their civil proceedings, but the wrongful detention claims were thrown out by the district court at the motion to dismiss stage. It is inconceivable at this point that the United States would say that they were required to bring evidence on a claim that never made it to the trial court. They were precluded from bringing any written testimony on their behalf in their bond proceedings as well. As I noted, this case is not about the wrongfulness of the asylum, it's about the wrongfulness of their detention. Whether or not the petitioners appealed to this asylum decision is not relevant for the purposes of this hearing. Regarding the facts that they settled their condition...
Estás hablando muy rápido y entonces se le hace muy difícil a los traductores,
Okay, yes,
a los intérpretes.
I'll
Sí, por favor, un
Okay.
poquito más despacio.
Yes, I apologize. Regarding the fact that they settled their conditions claims for their detention, again, the conditions claims are not at issue today. What's at issue is the wrongfulness of their detention as a whole and the lack of due process that they've suffered over the last 2 decades. Whether or not claims that are related to this case but are not at issue today is not of relevance to the court and should not be considered. The United States also discussed the fault of the falsification of their documents. This was the fault of their immigration attorney, who has already been federally charged and convicted on these claims. The way he addressed petitioners was deceitful, and they were not aware that he was falsifying their documents. Again, this is not of issue for the Commission today. I would just like to address that point. Regarding the United States position on the fourth instance formula, both Marcioni and Carranza The Commission said that a party may bring a claim even if it was issued by a domestic court acting within its competence and under its judicial guarantees, if a possible violation of the Convention has occurred, and specifically on the right to fair trial. Here, the petitioners are arguing that their right to fair trial has been violated, and they have sufficiently alleged several violations of the American Declaration both today and in their written testimony. With regard to the United States testimony regarding changes made to immigration detention, these changes have been made since the brothers' release, and they're irrelevant because they don't address the harms that the brothers suffered. The changes made since 2005 do not make the brothers whole. As they've aptly testified today, the brothers' abuses are long-standing and ongoing and must be remedied by the United States. The United States' refusal to remedy these abuses is part of a pattern of denying justice to individuals harmed by the state's rights abuses post 9/11. Many individuals have attempted to sue the United States and its agents in U.S. courts for the rights violations they have endured during this period. Yet, time and again, domestic courts have used procedural mechanisms to dismiss these claims. This hearing thus represents a unique and singular chance to have these claims heard on their merits, as is so often not the case in domestic courts. This case is also part of an ongoing and increasing effort by the United States to simultaneously restrict immigrants' ability to assert their rights through the judicial process and to grant immunity to federal government officials that violate those rights. Courthouse doors are closing to non-citizens in the United States who have a right to remedy under both national and international law. The United States is constricting the application of fundamental rights whenever they are linked, however loosely, to questions of immigration or citizenship, a clear violation of their obligations under the American Declaration. Thank you.
Bueno, muchas gracias. Le quedaron unos 14 segundos nada más. Le pregunto al Estado si desea hacer uso del derecho a dúplica.
Thank you. I'd like to say that we were in part our responses were responsive to things that were said by the petitioners today, so wanted to make that clear. Additionally, some of the allegations that have been raised today are beyond the scope of the commission. It appears that petitioners are now trying to make an actio popularis claim, which is beyond the competence of the commission to entertain those claims. I'd like to turn it back over to my colleague to describe a little bit more about additional steps that DHS has taken, in part given Motion's testimony regarding segregation earlier today. Thank you.
Thank you for the opportunity to give a few follow-up remarks. The first thing I want to reiterate is that civil immigration detention is non-punitive. Once a non-citizen is transferred into ICE custody, ICE makes a custody determination based on a number of factors. With limited detention capacity, we use those resources to detain non-citizens to secure their presence for immigration proceedings or for eventual removal from the United States. That includes those whose release is prohibited by law, as provided by the Immigration and Nationality Act, or those that ICE determines would be a public safety risk or a flight risk during the custody determination process. It's very different from criminal detention in that way. And then second, briefly, on the issue of segregation or solitary confinement that petitioners noted in their petition, that they had been subject to segregation and detention. U.S. law prohibits the use of special management housing in a manner that would constitute cruel or unusual punishment or without due process of law. The United States remains committed to preventing abuses with regard to detention conditions generally, and in particular, protecting detained non-citizens from abuses and bringing to justice those who commit them. In September of 2013, after petitioners' detention admittedly, ICE issued a directive on the use of segregation for ICE-detained non-citizens, which established enhanced ICE policy and procedures for the review and oversight of decisions to place ICE-detained non-citizens in segregated housing for more than 14 days, or for any length of time in response to a health condition or a special vulnerability. This directive enhances reporting requirements, and requires ICE to evaluate the appropriateness of continued segregation and to consider potential alternatives. In May of 2020, CRCL launched a periodic review of ICE's segregation oversight program. That review focused on how ICE headquarters and our field offices have implemented the requirements of the directive and the related policies and procedures. And on September 28th of last year, CRCL sent ICE a memorandum with 31 global system-wide recommendations to strengthen ICE oversight of segregation and better protect civil rights and civil liberties. Our segregation policies and oversight were also reviewed by the DHS Inspector General in October of 2021 and the Government Accountability Office in October of 2022. ICE is currently evaluating the segregation program and considering enhancements and changes in standards and oversight now. Thank you again for this opportunity to address the Commission.
Bueno, muchas gracias. Voy a pedirles a ambas partes que de las preguntas que se van a hacer para tener con el asunto del tiempo, las respuestas pueden presentarse por escrito. Entonces le voy a dar la palabra a mis colegas para las preguntas a ambas partes. Comisionada Roberta.
Thank you, Commissioner. Give me time. I'm asking Commissioner Esmeralda to give me time because I have so many questions and so many thoughts, but I'm going to be...
I can ask you.
Yeah. So you can, but I'll try to be disciplined. I have some questions for the state and one or two questions for the petitioners. So, as I understand it from the brothers, there were two periods of detention. Detention, I believe, in 1999, and then also detention in 2001. The detention in 1999, from what I can understand, was related to immigration irregularities. Is the state's assertion that the detention that took place in 2001 also related to immigration irregularities? Or is it that this detention was also related to allegations of terrorism? So what was the cause of the detention in 2001, and was it different from what happened in 1999? If charges of terrorism were also invoked to justify the detention in 2001, what was the evidence of that terrorism besides the LA cell list to reasonably support the framing of the detention as part of terrorism as part of the framing of the detention? And was that evidence supplied to the brothers, the evidence of terrorism besides the LA list and the attendance at the rally? Was that supplied to the brothers for them to respond to? On the question of the detention, I understand from the state that the detention in the context of immigration irregularities, which is why I come back to the question of what was the purpose of the detention in 2001. But immigration-related detention is not meant to be punitive. It's meant to secure the attendance, as I understand it, at immigration hearings. But what we've heard from the brothers seems quite punitive. They're being held in facilities with persons who have been convicted of serious crime. They're being held in facilities where they may not be allowed to leave the lockup for 3 or 4 days at a time. This is the testimony that the brothers have given, and that seems punitive because you can hold persons in kind of low security but secure facilities if it's, if it's about irregularities. So I'm wondering, and also thankful to hear the testimony on enhanced policies and the reform of detention conditions. But would you consider, as described and maybe as you have investigated, the detention conditions between 2001 and 2004? Five. Would you consider that those conditions of detention may have crossed the line into cruel and unusual, particularly in the context if they were detained for immigration irregularities? And lastly, has there been any state review of charges of discriminatory detention on the basis of ethnicity post 9/11, and in particular in relation to the four brothers. Thank you.
Le paso la palabra a la comisionada Mantilla.
Muchas gracias, Presidenta. Thank you very much. I want only 2 or 3 things. For the petitioners, I'd like to know if there is any pending judicial proceedings against the brothers, and what about the status, migratory status, and also if the state, besides the agreement that they have, is there any other kind of support of reparation or remedies? Because they both of them mentioned about the impact psychological. So I'd like to know if there is any support for them, for the health. Okay, and in the case of the state, okay, I'm not going to go further about the admissibility. I understand that you disagree, but the commission already admitted the case, so, but just to mention, and I'm not going to mention either about the competence of the commission, just like to remind, as I always do in the case of the state, about the Filartiga Peñeirala case, what is very important about the law of nation, but only that. But the thing is that it really caught my attention because there are 4 brothers. No, it was 1 or 2, there was 4. So it's kind of, I'd like to know if there are more situation of cases of brothers and family, all of them, detained. Second thing is that what about the migratory status? What about the migratory status of the brothers now? What is the current migratory status now? And just finally to remind that besides the American Declaration of Human Rights, besides the treaties, the non-discriminatory principle is part of the jus cogens. Even the restatement or law of the United States recognize the principle of non-discrimination. Just to remind that. Thank you.
Gracias, comisionada. Comisionado Caballero.
Sí, muchas gracias, Presidenta. A los agentes del Estado. Un poco en la línea de lo que quienes me antecedieron de las comisionadas, me parecería que hay un intento de distinguir los temas del debido proceso de cualquier otra consideración. Y el tema de raza, de origen étnico, de origen nacional, cobra una enorme relevancia en estas materias, ¿no? Se ha dicho ahora, la comisionada Mantilla dijo que eran normas imperativas de derecho internacional, y evidentemente a partir de la Declaración Americana y del trabajo de los órganos del sistema interamericano de esta comisión, evidentemente el debido proceso está, digamos, imbuido en los temas que tienen que ver con la igualdad de grupos tradicionalmente desaventajados, sometidos, excluidos, marginados, y la dificultad de acceder con este acento a las consideraciones de un debido proceso en condiciones de igualdad de armas, se dijera. Entonces, yo escuché ahora lo que han dicho a partir de trabajar en los temas de segregación, etcétera, y el cambio de normas al respecto, pero yo pediría del Estado alguna consideración sobre los procedimientos judiciales tratados a partir de estas consideraciones de no discriminación, pero también incluso de posibilidades de igualdad de armas, en el sentido de cómo la condición racial, étnica, origen nacional puede jugar en contra de estos derechos frente a las Cortes en los Estados Unidos. Muchas gracias.
Gracias, comisionado. Le voy a dar la palabra al secretario ejecutivo Jorge Mesa.
Muchas gracias, Presidenta. De manera muy breve y solo para que puedan, si así lo consideran, responderlo por escrito. Entendemos, de acuerdo con nuestro registro, que hubo un acuerdo extrajudicial con el Estado en donde se recibió alguna reparación vinculada con condiciones de detención. Entonces, saber qué periodo específico abarca, cuál sería la reparación y cuáles serían los aspectos que, de ser el caso, consideran que quedarían pendientes para lograr una reparación integral. Solamente eso, Presidenta. Muchas gracias.
Bueno, muchas gracias. Yo solo terminaría señalando la importancia que tiene para la Comisión Interamericana alcanzar el análisis, el estudio de las peticiones en los términos en los que dentro de nuestras competencias efectivamente podemos tener. me uno a las preguntas que han señalado mis colegas, resaltando de manera muy particular el tema del debido proceso y de las reales posibilidades de acceso a la justicia que tuvieron los hermanos en este desarrollo de la búsqueda de su regulación migratoria. Para concluir, quisiera agradecer la participación de la delegación del ilustre Estado de Estados Unidos, a la distinguida representación de las presuntas víctimas, recordándoles que tienen un plazo de 30 días a partir del día de hoy para presentar sus observaciones escritas, y de esta manera damos por terminada esta audiencia. Muchas gracias.